Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
so
understand.
I'm kind of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. Within that 7 are included. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No.
Just
You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No. It's you.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate. For alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Anklemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No.
Oh, my God.
Your Honor, may we discuss setting a new bond for
Of course.
Oh, my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh, my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white, and Dustin knows that it's no tolerance.
Consider 75 or 2, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But fine, because.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was located.
What?
They saw the couple at the intersection.
Okay, they saw it. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
my understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're 0.1 mile away from the location. So for what?
Well, okay, I get that, but so we've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else. Was there another warrant that you said?
It's the aggravated assault. But Judge, I also would like to point out that
But they end up putting him in the car, And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. All right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know,
but they didn't hit. They took the one that I do not believe applies here.
let's read the code.
Okay.
Let's see what the code says, because you know there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. No. So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is.
Okay, so that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
but he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described.
They put him.
the
I guess did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean, did they have the authority to arrest at that time? Right.
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the Miss Clark.
And it's at that point they start to put him under arrest.
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's if the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but
we don't know. I mean,
okay, I'm just saying.
both he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet,
don't
I
Judge.
don't
Judge,
care. I
he
mean,
was in
but
the
I think that
process.
there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
Oh, I see. I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with.
Remember,
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
I mean,
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, so well then
The bond right now is set at $2,500.
Okay.
Your bond upstairs is set at $5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They just shared it with me.
Yep.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow. Yeah, give me a second.
She sent me an email from
If anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before even the last court date, and we
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I have an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, attempt to go to the class. So she's been going. She did already take a test, and this is the one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text you.
Texting who?
The instructor. Like, what I'm supposed to show you? Because I don't have no proof. Like, I don't have nothing.
Tell me, what have you done?
I went to the class.
Okay. Which class did you go to?
GED resource.
Okay. And because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number because I'd like to call them right now.
I have a number for you, Judge.
I'm going to put this on this.
Oh, Charles Jackson.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's
Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So, I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a basic education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED concepts. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depending on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that got the GED in 2 years.
I can't do 3 years. That's too much.
Well,
I know. I'm kidding.
No, I understand that.
She's been faithfully attending, though. Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay. So I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got, like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You
okay. You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job.
So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have the right to have an attorney present. If you're not for it, one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. Do you have the ability to hire a lawyer, Mr. Humphrey? Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back 2 metal sheets that lead to 2 large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again?
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property. Or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how the how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a look at it.
If you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of course, Judge.
So,
thank you.
But until that time, don't pick up a new case. Don't go back. All right. So, Vic, you want to give me a date?
Yes, Judge. How is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work?
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. Okay?
Thank you, Your Honor.
Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand?
An affidavit, which is a promise you're making to me. That's the only condition. Mr. Caldwell, don't drive. Now you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right, come on. Thanks.